Good morning. Discovery and deposition. So we talked about discovery and we went through all kinds of written discovery, and I'll kind of briefly summarize it below. Obviously, this is not legal advice. Please subscribe, share. Again, 100% of all items are 100% off today. And I am in the future, if you are so inclined, I intend to auction off a judge to the highest bidder. So that will be a future episode. We will see. I also will address MMTLP briefly at the very end of the video. So this discussion does apply to MMTLP, Tesla, and any litigation. A quick summary of kind of the procedural of how litigation goes. Just a very quick summary because we've addressed some of these parts before. But a complaint is filed which sets forth the claims. If it survives procedural challenges, then the fact-finding portion of the case commences. We start off with written discovery. We talked about requests for admission, which is basically a way of establishing fundamental facts. Then interrogatories, which are questions, some specific, some general. And then requests for the production of documents, which requires a written response and actually documents, physical documents or electronic documents, produced in response to category requests. After this is submitted, responses are provided, negotiations occurred, and all the discovery is provided, then all the information is synthesized and a case is basically made. Or at least most of a case is made, we will say. One important point that as to discovery, the part that we just discussed, the written discovery, the party's lawyer, so if I send discovery to the defendant, his lawyer will be intimately involved in the preparation of any responses. So even though the party, when they submit the responses, actually has to verify them under penalty of perjury, the lawyer, as to these particular items, has spent a lot of time and is involved heavily in the preparation and form of those responses. So to some degree that limits the use and errors in those kind of documents. It certainly lacks spontaneity if nothing else. However, all that information that is ascertained can be used at trial for various purposes, but you should also consider that 95% plus of all cases settle no matter how far the parties are apart. And I'm often amazed about that. I've been involved in cases where the parties hated each other. There was no chance that the cases could settle, but they did. I had one kind of a side story is I had a client once and he had violated a couple of court orders, so he owed the court money, and it was for discovery. So it was actually a discovery sanctions. He didn't do what he was supposed to do because he didn't want to. So the court sanctioned him, and he didn't pay the sanctions. So one day the court ordered him to appear. He came into court, and it was something like it was 11 o'clock in the morning. The court said, if you're not back before 12 with the payment of sanctions, and I think it was like $4,000, I'm going to put you in jail. He had two sheriffs come into the courtroom, and he had basically 45 minutes to run from the downtown LA courthouse to find a cashier's check for $4,000 and bring it back. He arrived at, I think, 11:57 a.m. and survived from having to go to county jail. That was a Friday. The problem with going in on a Friday is he would have spent the whole weekend in jail on a civil case for not paying sanctions. That same judge, by the way, I thought was terrible. Didn't know what he was doing, was terrible in court. And then in the end, he was a settlement judge, and he settled our case. He was brilliant at settling the case. So anyway, it was funny. My client almost went to jail because he was a jerk. The judge was terrible, but he ended up being excellent at resolving the case. So now let's move on from there. So after we get the written discovery, we begin the depositions. A deposition occurs usually in an informal environment. It's not in a courthouse, usually in a conference room. So it would be like the other attorney's conference room. There's a court reporter there who is physically taking down whatever is said, and the relevant attorneys are there, and the parties themselves or representatives of the parties can be there. They can't speak, but they can be there. The deponent, the person whose deposition is taken, So that's the person who's being deposed. They're called a deponent. That can be an individual person, or it can be a representative or an employee of an entity or a party. The idea of a deposition is to ask questions to elicit information that you can utilize the information that you have used to extract more information. And so you can find out from the deponent about the case, his or her background, elicit supportive facts of your own case, ascertain the facts that are claimed to support your opponent's position, obtain a written record of the testimony to prepare cross-examination at trial, lock the witness into a position, a recorded position, and to be able to use the information provided, develop alternative theories. There's other uses, but that's generally it. You're just basically locking them into a position and obtaining information to use in your case. As a general rule, most people like to avoid having their deposition taken. It makes most people anxious. The attorney for the witness is sitting there trying to have the witness answer as narrowly as possible. So there's a dichotomy there. The person who is conducting the deposition wants the witness to spill the beans about everything and talk about everything. And the attorney for the deponent wants the witness to shut up. So it's a constant conflict that goes on through the deposition. Objections can be asserted during a deposition. At times, there are arguments and instructions not to answer, which may result in motions and other things. However, unlike the written forms of discovery where the attorney can be dominant in terms of the response, in a deposition, in large part subject to counsel interrupting, which often occurs, the witness is on his own. And because of it, and being in a new situation, unnerving, people often state things in a way that can be twisted at trial, or they'll make errors. So that is often used at trial to impeach somebody's credibility. Often before a deposition, and I know I do it every time, the witness will meet with his or her lawyer and practice the questions that they suspect will be asked at the deposition, and go over the documents that will be covered at the deposition. So most times, I would say almost all times, the witness has been prepared prior to the deposition. So it's not like they go in cold, but they are on their own. And if they answer a question, the question is on the record. So how is this used at trial? What's the purpose of deposition testimony ultimately? One, you can read an opposing party's deposition testimony directly into the record as evidence at trial. So it's as if they're testifying. So you take out their deposition, and I've done this, I did it the last trial I did. You take out their deposition and you just read it into the record, and it comes in as direct evidence. And you could use that to make your case. Two, the deposition testimony itself helps you prepare direct examination for your clients. In other words, kind of helps you navigate where you should take your client in questioning them and in terms of what their cross-examination might be. And it also helps you prepare cross-examination of the opponent's witnesses. You use the transcripts, you try to find weaknesses, you try to use testimony or words they've used, and you have a transcript to use. So it's very helpful in preparing cross-examination. And three, if the witness testifies at trial inconsistently with the way they testified at their deposition, these inconsistencies are literally read into the record as a means of impeaching the credibility of the witness. So the witness testifies that the sky is blue, but in this deposition, they testified the sky was red. You can then read that testimony, the sky was red, into the record, and you could say basically at closing argument, well, here they said it was blue, and here they said it was red, so you can't really believe them. So obviously that's a simple example, but that's kind of what you're trying to do. So it's helpful for use in final argument when describing the testimony of various witnesses. you may be able to minimize the value of the testimony by attacking credibility. So, briefly, we have now addressed, at least generally, the concepts of written and oral discovery. I will deal with expert discovery at a later date. So in other words, cases sometimes have expert witnesses, and that has a whole set of rules for expert discovery, but it's not important at this point. Obviously, there's ongoing litigation involving MMTLP, and discovery will take this path if the procedural hurdles are passed, and hopefully they will be in various cases that are filed. As an aside, briefly as to MMTLP, I did make a demand for my physical shares as well as to arbitrate only the state claims and to try all the federal claims in federal court with the other defendants. My state claims, or at least the claims I have requested I want to arbitrate, include claims related to MMAT also. I expect to receive a reply in the next couple of days, and I also expect to receive papers, opposing and moving papers from the 3 named defendants as of now within the next 10 days or so, and I would expect I will be filing paperwork thereafter, and obviously I will keep everybody apprised as it goes. Anyway, be well. I will have more videos over the weekend and next week that'll be relevant, and be well. Have a good weekend. Take care. Subscribe.